We are almost at the end of the closing arguments, with the defense having submitted about 3 of their submissions already on accused number 1, 2, 3 and 5. Only one left now representing Gwabeni accused and number 4. With a lot of things said that will make the magistrate, Mr. Vincent Hlajwayo, to make a determination as to whether he grants or not the bail for the 5 applicants or 5 accused who are standing trial in this matter regarding the killing or the murder of AKA alongside his friend or business associate TIBZ Motsoane. With me is the legal expert Abigail Ngobeni, who's going to take us through about some of the matters that have arisen here from this matter. Thanks a lot for your time. Just what are some of the major takeaways from what has already been presented in the closing arguments?
Remember that the bottom line is for the defense to come and convince the court that there are exceptional circumstances that which, when you balance that with the interest of justice, they do allow their release on bail. But of note, which we have had today through the presentation that were made by the defense counsel, particularly for number 1 and number 5, Advocate Mlojo, it was particular to say that number 1, in as much as he's saying to the court that he needs to be released on bail, there's an issue of a medical certificate which shows that he's having asthma, but that medical certificate seemed to have been done while he was in prison. And the court confronted the counsel to say, explain the issue of him being inside the Westville prison but being able to appear in person before Dr. Mudli, and that may constitute or may work against accused number 1. And if you check the submissions of number 2 as well and number 3, there are a lot of issues. And as well, Advocate Mlojo touched on the issue of the 800,000, which does not appear on the bank statement. The bank statement of number 4 is purportedly submitted to the omission of that part, which means they submitted things that show the previous and after. But when it comes to the issue of the 800,000, it's intentionally removed. And the court was particular to say that may also show that there's an intention to hide certain information, the issue of transparency. And if you check, Gwabeni, who is termed the mastermind, have not yet presented these arguments, but because this case is interlinked, other counsels seem to be talking on issues that always overlap. And if you heard the issue of number 3, you will also agree with me that it will not have been very easy for the counsel, because he also admit that there are 4 other murder cases that he is linked to. A firearm which is suspect to have committed this particular matter was found in his possession, and it links to other 4 matters where there is a loss of life. And the court was particular to say, can this court also draw an inclination to say he's also linked, highly linked to violent crimes, and such factors holistically may also jeopardize their admission to bail.
I will say that the defense so far, what they've represented here so far, presented, have got their backs on the wall.
It's very complex to say that. I'll draw you back to Advocate Mlojo's submissions. The court went back to the issue that I once raised to say, can you really say this court is responsible for the differences in the times which are in the DPP's affidavit and the IO's affidavit? This court was particular to say its main duty is to check whether these accused persons will be able to stay trial, and if there is a case to answer, and if they are to come and submit and say there are differences, this court says such differences will be looked at by the trial court. This is not a trial court. So I think that the applicants still have a very high mountain to climb to show the court that the interest of justice permits their release on bail.
Will you be satisfied with how the magistrate Vincent Hlajwayo is interjecting at some of the points or some of the inferences by the defense so far?
I'm satisfied, but remember that what I think in law may not be what somebody think. What I noted when we started today is the fact that he said some of the heads of arguments were sent to him very late, so he did not have an opportunity to read them in full before he came for the sitting. Then that means as and when there is a point that he wants to engage each of the defense counsel at this particular time. He's then using that opportunity to understand certain factors clearer, and it's within his right as the presiding magistrate to say, address me on this. And if you check how he interacted with Mr. Volmarans, he even said, let's do justice to the applicants. Let's hear all factors. Are you satisfied that you have addressed me on issues of importance? He then went to an extent of saying, on the issue of 800,000, your client did receive payment. Address me on that. You understand? So he was trying to go overboard to say, let's touch on all issues. And him interjecting, I think it's a manner of interaction that happens always in court.
Okay, thanks a lot.
Thank you very much.
Okay,
I appreciate it.
That's the legal analyst, Abigail Ngobene.